All right, I already knew this. I'm going through a wrongful eviction right now. And the landlord, the first people that bought the building, decided to raise the rent without making any mandatory repairs. And I went through with the landlord before that, and the one before that, and before that. The last one said she was here to make money, not spend money, and shortly after sold the building without making the repairs. Okay, so when a lawyer advises a client to break the law, they violate ethical rules, e.g., Rule 8.4 of the Model Rules of Professional Conduct, or risking disbarment, criminal charges such as conspiracy against rights under the color of law. That's because they took the oath to the Constitution, and those are their constitutional duties, which are yours, mine, everybody's constitutional rights. So he must abide by the rules of professional conduct. Otherwise, that's deprivation of rights. And aiding and assisting his lawyer to, or his client to break the law is a conspiracy against rights under the color of law. And civil malpractice lawsuits such as conduct violates attorney-client privilege via crime, fraud, exemption, allowing communications to be revealed. Professional discipline, the State Bar Association can investigate, resulting in sanctions ranging from suspension to permanent disbarment. Criminal civil liabilities, lawyers can be charged with criminal offenses like fraud or conspiracy, again, conspiracy against rights under the color of law, or sued for malpractice. Reputational damage, the attorney may face the loss of their license, reputation, and clients' ethical obligations and requirements. Remember, you can also cite them for ethical violations. You have to, I forgot what it's called, OGE office or OEG, Office of Ethical Government, something. Mandatory withdrawal. If a client insists on illegal misconduct, the attorney must step away or seek court permission to withdraw. Counseling against crime. A lawyer must first try to dissuade a client from criminal acts such as perjury. Exceptions. Advice may only be permissible if it is designed solely to challenge laws constitutionally in a test case. If you believe a lawyer is engaged in such behavior, you typically can file a complaint with the disciplinary board of the highest court in your state, as noted by the American Bar Association. So when you file a complaint for violating the rules of professional conduct, that goes to your state Supreme Court. Okay, can lawyers just ignore the law if it's against their client's interests? No. Oh, that's on Reddit. No, but no. Can a lawyer advise a client to break the law? A lawyer cannot advise a client to break the law. If the lawyer has a good faith belief that the law rule is invalid, the lawyer may be able to take steps. Okay. I knew this a long time ago. I used to help people with evictions back in the 90s when I used to live in Brighton Park. And a lawyer advised, oh, sorry. Hit the wrong button. It says landlord fixes everything. Illinois landlords are legally required to keep rental properties in habitable condition, covering essential services like heat, plumbing, water, and electricity. They must address in writing non-emergency repairs within 14 days. If they fail to do so, tenants may exercise options like hiring professionals for repairs or deducting the costs from rent. Habitability standards. Landlords must ensure the unit is safe, sanitary, and in compliance with local building codes. Time frame for repairs. Non-emergency repairs must generally be addressed within 14 days of written notice. Emergency situations. For emergencies such as no heat, the 14-day rule does not apply. Landlords should address these immediately. Repairs and deduct. Tenants may be able to make repairs themselves and deduct the costs up to $500 or half the month's rent, whichever is less. If the landlord fails to act, what this requires following strict notice procedures. Documentation is crucial. Tenants send written notice of issues via email, letter, and keep records. If the repairs are not made within 14 days of written notice, tenants may have legal rights to repair and deduct. In serious cases, terminate the lease as outlined in this guide from the Illinois Legal Aid. Okay, but so they're there to make repairs. Multiple water leaks in the bathroom, in the kitchen, black mold, and in the kitchen, to cover those leaks, he painted. That was it. Had some guy paint, did a really bad job, and only painted a portion of the kitchen. And said, okay, now you pay the increase. In the bathroom, he said they fixed the bathroom. But after they replaced the ceiling, after such a long time, after replacing the ceiling and the venting and the fan in the bathroom, he wanted to, again, told me, now you pay the rent increase this month and last month. I said, no. Because the ceiling in the bathroom leaked again. Plus, there's the water. The water comes out orange sometimes. You could see rust in it. It discolors the sink. Use the hot water. When it dries up, it stains the walls, the ceiling, leaves discoloration. Sometimes black stuff comes out. And I have videos. They didn't want to see nothing. And I've spent money making repairs before, and I never get reimbursed, and so no, I just want the landlord to make the necessary repairs. The drainage, it's slowing up, backs up. That's what's causing the mold coming from the bathtub and the sink and around the toilet. And the plumbing just has to be redone, incoming and outgoing. And it's not my problem that's heavy expense. But they should have took that up with the landlord before they bought the building. It's required in disclosure. The landlord before that, it's required legally in disclosure to let them know that they have all these problems and they have a time frame to which fix this stuff, and nobody's doing that. So that's my whole argument in court. I mean, so I'm quite sure the landlord is doing what he can to put this building up for sale before he winds up with all these expensive expenditures. The water damage from multiple water leaks in the bathroom and the kitchen. There was one in the front room. The door is warped. It's old. They tell me stick towels or blankets or whatever in front of the door, and it just needs to be replaced, the frame of the door. I know because in my younger days I did stuff like that. But either way, these are repairs that are mandatory. Just thought to let you know what I'm going through. And I'm taking the rules of professional conduct and the code of judicial conduct with me because the lawyer assured me that the judge he knew personally, and she was basically going to side with him, and he laughed at me and talked over me, and I tried to share what I have is called, part of discovery, what I will use in court as evidence to show that every landlord and their counsel ignored my request for these mandatory repairs. And everybody wanted to raise the rent and got mad because I wouldn't pay the increase. I wouldn't pay the increase because they wouldn't fix anything. Thank you. Good night.